Is this better? For the love of Benji. I don't understand what the fuck is up with this microphone sometimes. I'm so sorry. I don't know. It's this fucking thing. Oh god, am I gonna have to start over? I'm gonna have to start over, aren't I? Uh, okay. All right. I'm just gonna remember this, Mark. Thank you, guys. Um, 4 minute 15 seconds. Whew. Okay. Siri Bear is like, oh Lord, I'm glad I'm not the only one. I thought you were on drugs. Start over. Judge's orders. Yes, ma'am. All right, here we go. Woosah. It's been only 4 minutes, Larry. Be glad that you didn't catch it at the 30-minute mark when everybody would be like, Larry, and I'll be like, do I have to reread the complaint? Whew. You want me to keep it? I don't know. People would just be like, what the fuck? My hair is not cooperating. Like, ah, kill me now. Mulligan. Thanks, Dr. Gia. I thought I did. No, it's this thing. It's like when I plug in the headset, it distorts it sometimes. Like I never have this issue with the microphone, but with this, every like 12th, 15th time I go live with this, it will do something. I had the similar thing with phone calls. Sometimes they sound like a chipmunk, but it's never intentional. I'm sorry, you guys. Why would I do that to you? That seems stupid. All right. Ugh. Yeah, I'm pulling the mulligan card again, Judge. Mr. Prosecutor would like to try again, Your Honor. I love you, chat. You guys are so amazing and patient. You stayed and you were like, you know what? Fuck that. I'm gonna listen to Larry the goddamn squirrel. I don't give a shit. Yeah, you guys. Good morning, everybody. I really hope that you are enjoying the show. And everyone's like, please, DUI guy, tell us more, Larry the Chipmunk Guy. All right, this show fucking took a turn. Welcome to Raw Law Unfiltered, where you crack up like a motherfucker because you listen to DUI Chipmunk Guy. All right, let's bring it back. And scene. Hello, everybody, and welcome back to Raw Law, Not Chipmunk Unfiltered, with your host, the DUI Not Chipmunk Guy. Today, we are going to be covering some more Amber Heard stuff. So, today and this Thursday, there are two lawsuits. One of her insurance companies fighting amongst each other, and the other one is the lawsuit, which is covering what we're covering today, is the lawsuit of her insurance company against Amber herself. What? I thought this was over. I thought the case was over. No, the case is only just beginning because the suit between her and Johnny Depp, that's over. That's settled. That's over and done with. No question, no questions asked, right? But you still have two other lawsuits in California that are still Amber. She's still being sued. These lawsuits have absolutely nothing to do with the settlement. The settlement is one thing, the lawsuits are something completely different. They're alive and well. And actually, her insurance company has until January the 13th to respond. So, and today's January 3rd, last time I checked. So that's 10 days from now. Obviously, it's alive and well, but we'll get to that in a moment. First, why am I doing it today and Thursday? What are you doing tomorrow, DUI guy? I'm glad you asked. Tomorrow, we are going to have on our show, back by popular demand, a guest that has been on my show before. Her name is Claire Best. You all remember Claire? She is an investigative reporter, and she is going to talk about how Amber Heard, Michelle Dauber, Title IX, the sexual assault accusations on campus, and FTX, question mark, question mark, question mark, how those four are related. So wait a minute. Are you telling me that Amber Heard is in some way, shape, or form also involved in the whole FTX scandal, the biggest cryptocurrency theft, conspiracy, and debacle of the century? Why am I not surprised? She's literally got her hands in every pot, doesn't she? But I don't want to spoil the fun. I'm going to let Claire fill that in for everybody tomorrow. And she's going to be on the show at 10 a.m. Pacific, 1 p.m. Eastern. So tune in for that. If you haven't seen her first video, by God, you have to go see it. I have never received such compliments on a guest before in my entire career. As a YouTuber, as a lawyer, doesn't matter. She had such inside information stuff that I've never before had the pleasure of sharing on my platform. So we're going to repeat the cycle hopefully tomorrow. So what is going on? Why are we talking about Amber again? Right? Like, wasn't it over? Like I just said, it's not over. The suit with Johnny is done, but she still has to pay the $1 million, right? Well, she doesn't want to pay. She does not want to pay. Her insurance company's like, no, I'm not doing it. New York Marine. So let's see what they have to say. This is what I started on, and I want to talk about it. So as you can see, attorneys for plaintiff, New York Marine General Insurance Company versus, oh my God, look at that, our favorite anti-hero, backed by not popular demand, Amber Heard. She is once again a defendant in another action. What? How is this real? What is this about? Plaintiff New York Marine alleges as follows. So jurisdiction and venue. We got to start with jurisdiction and venue. This is the lawsuit. This is the lawsuit against Amber, that we are not paying your $1 million. You, lady, are on your own. You have to pay your own $1 million that you owe Johnny, that you agreed to pursuant to the settlement, right? So now that the suit is over, now that the suit has been settled, there's still the question of the $1 million. Who has to pay the $1 million? Is it Amber or is it her insurance? Johnny is out of the picture. Johnny has nothing to do with it. Johnny doesn't care. Johnny is just sitting there with his hands stretched out, waiting where it comes from. It's just got to land there. Now the question is, Amber doesn't want to pay. Her insurance doesn't want to pay her. Now Amber has to fight against this lawsuit. That's exactly what is happening. Oh my God. So $75,000 in controversy. Fine, we get it. This is standard boilerplate stuff. And this is right where I finally realized that I sound like a chipmunk. In this action, New York Marine seeks a judicial determination of the respective rights of the parties under an insurance policy issued under the Black Sky Incorporated, which includes Amber Heard, the named insured. What the fuck does that mean in human language? I will tell you. It simply means, please, court, this is the Central Court of District Court of California, District Court, you're asking them, the New York Marine is asking them, do we have to pay this? Now, they're going to issue arguments as to why they should not be paying them $1 million on behalf of Amber under her policy. But this is what they're saying. They're telling the court, hey, court, we need your help to decide. Please issue a declaration. That's what they're saying. A judicial determination of the respective rights of the parties under an insurance policy. So we have an insurance policy. Amber Heard is the named insured. Please tell us, do we have to pay? Yes or no? Okay. Now, it's authorized under such and such section. Venue is proper because a substantial part of the events given rise occurred in California. That's all stuff. Now, the parties are New York Marine and Amber Heard. Factual allegations. So now this is what the New York Marine is saying. New York Marine issued a policy number such and such to insureds under Black Sky and Amber Heard for the policy period of July 18th, 2018 to July 18th, 2019, with a per occurrence limit of liability of $1 million. This is going to be called the policy. A true and correct copy is included. The policy includes a comprehensive personal liability coverage part, which provides coverage for damages because of bodily injury, property damage, or personal injury caused by occurrence, which the policy applies, which the coverage applies, excuse me. The policy defines personal injury to mean injury other than bodily injury arising out of one or more enumerated offenses included in the policy, which includes oral, and this is important, oral or written publication of materials that slanders or libels a person or organization, including other forms of defamation, and oral or written publication of materials, including the forms of defamation that violates a person's right of privacy. So that is exactly what the coverage under the policy was instituted to provide. So if between the period of July 2018 to July 2019, there has been a publication, and as we know, December 2018, there has been a publication in the Washington Post. That policy will cover that defamatory conduct. So, why are they filing this lawsuit? Why don't they just give her the $1 million and call it a day? And this is where it gets very, very interesting. The underlying lawsuit. On March 1st, 2019, John filed the lawsuit in Fairfax, Virginia, as we know. Fairfax, Virginia, excuse me. In the underlying action, Depp sought and is seeking damages for defamation based on an op-ed allegedly written by Heard, as we know, and published in both the online edition of the Washington Post of December 18th, 2018, and the printed edition the following day, which was republished by Amber Heard in a tweet. By the way, notice that they are calling it a republication. That's also important. A true and correct copy is included as Exhibit B. On or about September 4th, 2019, Heard tendered the underlying action to New York Marine. So she let know her insurance company, hey, I am being sued. I paid you for this insurance policy. Please cover my ass. Standard stuff. On October 1st, 2019, New York Marine accepted Heard's defense of the underlying action, subject to a reservation of rights. Specifically, New York Marine advised Heard that New York Marine would provide a legal defense. California law does not permit an insured to indemnify the insured. No indemnity can be provided. We'll get to why that's important in a moment. Right now, just focus on the big picture stuff. At the time Heard tendered the underlying action, the law firm Cameron McEvoy, PLLC, was defending Heard in the underlying action. When New York Marine accepted her defense, they agreed to continue the defense of Heard through this firm, this Cameron McEvoy. You remember a Cameron McEvoy firm representing her? Exactly. They were left out to dry. They were thrown on the back burner. New York Marine is informed and believes, and on such information and belief alleges that Heard or her agents instructed other firms defending Heard in the underlying action to not include Cameron McEvoy in Heard's ongoing defense. And as a result, on or around November 2nd, 2020, this is way before the trial, Cameron McEvoy simply withdrew from the defense of Heard in the underlying action. Now, why is that important? Number one, your own insurance hires these guys and gals to represent you, and you just ignore it and hire your own. That's already a problem. That's already a red flag. At least let the insurance know that, hey, I am also going to be hiring these people over here, because they're the ones fronting the bill. Don't forget. You never want to be deceiving your own insurance company, and that sounds like she was doing here. The underlying action proceeded to trial on April 11th of 2022. On May 27th, there was a jury instruction issued by the court. And in the jury instructions, the court in the underlying action instructed the jury that with respect to liability issues for Depp's claim against Heard, the jury the jury's verdict must be based on the facts as you find them and on the law contained in these instructions. The jury instructions also instructed the jury with respect to liability issues. And this is the most important piece of this whole lawsuit by New York Marine. Why they're like, Amber, we are not giving you a dime. Look at this language. Remember, this is going to look very, very familiar. The issue for the jury to decide were whether Ms. Heard made or published any of the following statements. Amber Heard spoke up against sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. As a finding instruction, the court in the underlying action instructed the jury that it shall only return your verdict for Mr. Depp on the claims for defamation if they prove by greater weight of the evidence that Heard made or published the statement. The statement was about Depp. It was false. There was a defamatory implication. The defamatory implication was designed and intended by Ms. Heard, and due to the circumstances surrounding the publication of the statement, it conveyed a defamatory implication to someone other who saw it other than Mr. Depp. And if Mr. Depp further proved by clear and convincing evidence that Ms. Heard made the statement with actual malice. If Mr. Depp failed to prove any or more of the 7 elements above, then you shall find your verdict for Ms. Heard with respect to the above statement. Now, we know what happened. We know that the jury rendered a verdict on behalf of Mr. Depp on all 7 elements of the defamation charge, right? And this is where New York Marine raises its battle axe and starts chopping fucking heads off. Literally cutting Amber's, think of it as think of the what's that, the Hydra. Remember the Hydra? It's got like the beast with 3 heads. They're literally just like slicing and dicing until the Hydra just drops. And the Hydra in this case, metaphorically speaking, is Amber. The court in the underlying action issued nearly identical findings for the other 2 statements, instructions on the other 2 statements. And on June 1st, the jury reached a verdict in favor of Depp on the counts of defamation based on all 3 statements. This verdict was incorporated into a judgment order, which was entered by the court in the underlying action on June 24th. So that procedural stuff, and it's attached to this complaint. As detailed in the special verdict form with regard to each of the 3 statements, the jury found that Depp had proven all single one of these questions in the affirmative, which we just covered. By answering yes, the jury also answered yes to the question, do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? The jury awarded Depp $10 million, $5 million in punitive, which was later reduced to $350,000 statutorily. Now we know all of this, right? And here comes the head chopping. You ready? Oh, this is so beautiful. This is absolutely beautiful. The first cause of action. Now, again, fancy language, and I'm going to simplify it for you as I always do. Declaratory relief as to plaintiff's duty to indemnify Heard for the judgment order under the policy. In English, do we have to pay, yes or no? Plaintiff incorporates by reference, blah, blah, blah. California Insurance Code provides an insurer is not liable for a loss caused by the willful act of the insured. Let me read that again. An insurer, meaning me, New York Marine, is not liable to pay for a loss caused by the willful act of the insured. So if you do something intentionally, willfully, I don't have to pay you. It's only negligent acts that are covered by insurance policies. Boom shakalaka. Oh my God. But he is not exonerated by the negligence of the insured or of the insured's agents or others. This provision is an implied exclusionary clause, which by statute is read into all insurance policies under California law. Standard language. The jury's factual findings, they go on, establish that Heard's liability is caused by the willful acts of Heard. As a result, as a matter of California public policy and pursuant to the code that we just read, the policy does not provide coverage for Heard's liability as reflected in the judgment order entered on June 24th. Boom, mic drop. An actual controversy has arisen and now exists between plaintiff on the one hand and Heard on the other with regard to the duties and obligations that they owe under the policy to Heard with respect to the judgment order. And we're asking the court to please, basically in human language, let us know. Do we have to pay or not? Heard, of course, disputes plaintiff's contention and asserts that the policy provides coverage for Heard and the judgment order entered on June 24th. Of course, she's going to say, no, you do owe me this money. Please pay the $1 million. Due to the actual and present controversy described above, pursuant to such and such statute, plaintiff requests a judicial declaration of rights. So basically, this is, again, court, we need your help. Please intervene. Please tell us, do we have to pay or no? That's what they're asking the court to do. They believe that plaintiff has no obligation. Same thing. Again, this is about the judgment in the underlying action, declaratory relief as to the plaintiff's duty to indemnify Heard for any judgment in the underlying action. This was declaratory relief as the plaintiff's duty to indemnify Heard for the judgment order under the policy. Okay? And this one is, do they have to pay under the underlying action? Basically, it's the exact same language. We do not have to go over it. Excuse me. It is pretty much the exact same thing, only in a different context. Same thing here. With respect to, this is the third cause of action. Do they have a duty to defend Heard? This is cause of action number 3 in the underlying action under the policy. There's a typo here. Action under the policy. Same language. And do they have a duty to defend and indemnify Heard in the underlying action under the policy itself? So in the action and the policy, do they have a duty to defend under the action or the policy? 4 causes of action. And they're asking the court to answer all 4 of these questions. Okay? And the prayer for relief. Now, we'll get to the response in a moment, so don't go anywhere. If you think this is it, oh boy, this is only the beginning. You don't even know what you just got yourselves into, because this is just a complaint by New York Marine. Don't forget that Amber also responded to this, her lawyers, of course. Wherefore, plaintiff respectfully requests that this court enter a judgment declaring that plaintiff has no duty to indemnify her. Basically, we don't have to pay. Please tell us, court, we don't have to pay under the policy because her conduct was willful and we only covered negligent acts. Plaintiff has no duty to indemnify Heard for any liability, and we have no duty to defend her, either give us our costs that we have to litigate this shit. We want to get paid. Not only are they like, we don't want to pay her anything, they also have the audacity to be like, we also want to be paid because we have to bring this action telling her we don't want to pay. I mean, the balls on these fucking guys. I love it. I absolutely love it. And of course, grant such further relief as the court may deem is proper. Now, the answer. So this is Amber's response. Defendant Amber Heard hereby answers the amended complaint as follows. So Amber is like, I don't like this. Naturally. I don't like the fact that my insurance company is not paying. I like money and I need to be paid. And especially now that she owes Johnny $1 million pursuant to the settlement agreement. She needs this money. Otherwise, it's going to be coming out of her own pocket. And I don't know if she can afford it. Unless she still has some savings up. I know she sold that house in, was it out west, Arizona, New Mexico, somewhere. So if she has that money, she can pay him. But hey, it's much better when somebody else pays for your shit than you have to pay cash money out of your own bank account. Let's be honest. That's anybody, right? So what's going on here? Jurisdiction and venue. Again, this is standard boilerplate stuff. you're going to see a lot of like admissions, denials. It's going to look crazy, you would think, until it gets even crazier. So buckle up, Buttercup, because you're in for a ride. Answering paragraph 1, Ms. Heard admits the allegations in this paragraph. This is all going to be like jurisdictional stuff. She's pretty much going to deny, or excuse me, she's pretty much going to admit. There's very little to deny when it comes to jurisdiction and venue, unless you're going to dispute and you think that it should be filed somewhere else. She admits, does not dispute venue. Admit, standard stuff. The parties, again, Ms. Heard lacks sufficient information to admit or deny the allegation of this paragraph, therefore denies them. She denies with respect to New York Marine. She doesn't know anything about it. And of course, Ms. Heard admits that she is a natural person and was domiciled in California at the time of filing, except as expressly admitted. She denies the allegation in this paragraph. Remember the whole thing about she resides in California. She doesn't reside in California. She's not a domiciliary of California. She is a domiciliary of California. Like, we didn't know where she was living at that one time when she was denying as to where she resides so that she didn't have to pay Johnny any money. But now that that case is settled, I mean, none of that really matters at the end of the day. So for the most part, we can kind of just move past it, or at least for our purposes today. And the factual allegations, again, the insurance policy. Ms. Heard admits that she was the named insured and, of course, denies some stuff, admits the policy contains coverage. She admits the definition of personal injury. So standard stuff she's going to admit, no question about it. The underlying lawsuit, she also admits most of the basic stuff. Admits. Nothing surprising. This is normal stuff. Everything is pretty much admitted. Now, let's get to the causes of action. Because there's nothing to deny, by the way. Some of you wondering, like, why is she admitting? Why is she admitting that these things? Because they happened. She's literally, it's like the jury trial stuff. Was there a jury instruction? Obviously, so I'll admit that. Was this read to the jury? Was this paragraph read to the jury? Obviously, yes. So I'm going to admit that. You know what I mean? That obvious stuff. Now, of course, Amber is going to deny that she is not owed any money. Standard boilerplate language. She admits some stuff that is obvious, but anytime that New York Marine says we don't have to pay because your conduct was willful, Amber is going to deny. That's obvious. And she's going to do that once for cause of action number 1. She's going to do it twice for cause of action number 2. She's going to do that 3 times for cause of action number 3. See, they also caught the typo, the underlying policy. And she's going to do the same thing for cause of action number 4. And here is where it gets funky. Affirmative defenses. Now, what are affirmative defenses? Affirmative defenses are defenses that you must state affirmatively. That's why they're called affirmative defenses. If you don't state them, you waive them. So she names a few affirmative defenses. First affirmative defense, failure to state a cause of action. New York Marine is barred from maintaining its First Amendment complaint and each cause of action therein because they fail to state facts sufficient to constitute a claim against Ms. Heard. Huh? What? New York Marine's first cause of action is not ripe and not justiciable insofar as it is contingent on the entry of final judgment in or other final resolution of the DEP lawsuit. Now, this was filed a few weeks ago, so it is not exactly current, as you can obviously tell. Why? Because we have a settlement. The case is over. The case is done. There is no more litigation to be had on the trial level or on the appeal level, right? So this is a little bit outdated, and they're, of course, going to have to sort this out in the coming days and weeks and possibly months. But their first defense was you failed to state facts enough to constitute a claim for relief. Okay, fair enough. Simple stuff, right? But to argue there's no subject matter jurisdiction, like the case is not even ripe for discussion yet because it's still open. So basically, pause the lawsuit, a very silly but probably a necessary evil. Third affirmative defense, there's no substantial prejudice. New York Marine cannot maintain its fourth cause of action because it cannot establish that it was actually and substantially prejudiced by any unexcused alleged failure of Ms. Heard to satisfy any condition under the policy. So basically, that says you should pay because you didn't suffer. What? What about the fact that your conduct was willful? Again, that's you're completely like hip skipping, hip skipping, and hop skipping and jumping over the main issues. But okay, fourth affirmative defense: unclean hands. Oof, man, New York Marine is about to get COVID, right? They need to be washing their hands some more. No, unclean hands has nothing to do with washing your hands after going to the bathroom. Unclean hands means that you were in some way, shape, or form complicit in the conduct or the negative conduct, and therefore you have waived your right to a lawsuit if you were in some way, shape, or form involved in the conduct. New York Marine is barred from maintaining its First Amendment complaint and each cause of action therein because of its unclean hands with respect to the policy, the events upon which its cause of action are based, and its conduct. Oof, nasty stuff, huh? Next, fifth affirmative defense: waiver. You waived something. By its conduct, representations, and omissions, New York Marine has waived, relinquished, abandoned any claim for relief in its subject to its First Amendment complaint. I mean, this is bonkers. They're going for the whole kit and caboodle now, aren't they? The sixth one is estoppel. Now, that's a fancy one. It sounds like estoppel is actually really, really simple. You just can't do it for whatever reason. You just can't do something. You're stopped from it. Like the word stop is in it, right? Because of some certain conduct, you are stopped from asserting the claims for relief against Heard. Breach of contract. Now that's an obvious one. You had a contract. Amber signed it. You said, if this conduct happens, I will pay up to $1 million for each action. An action happened, pay up. You refuse, you're in breach of contract. Simple stuff. That's number 7. Number 8, bad faith. When you fail to act in a certain manner, failing to honor the conditions of a contract, you're acting in bad faith. If you're acting in bad faith, that's tortious. You're in breach of an implied covenant of good faith and fair dealing, and it's bad and unreasonable conduct. And number 9, to the extent stay, don't go, please stay, right? No, that's not what that means. To the extent that the issues or facts involved in this action overlap with or could implicate issues involved in a debt lawsuit, this action should be stayed. So basically, this is a little premature. It kind of goes back to number 6, I think it was. It's not estoppel, sorry. Number 2, it goes back to number 2. There's no subject matter jurisdiction because it's not ripe yet, and it should be stayed until we get it resolved. So number 2 and number 9 are kind of linked together. They're kind of married. And both of those, by the way, since the settlement a couple weeks ago, are also both kind of moot, since the issue is moot. The case is resolved now. So number 2 and number 9, affirmative defenses, are no longer viable. And we will see that evolve as this lawsuit progresses. Now, prayer for relief. Ms. Heard obviously asks the court, please declare that my insurance company is not entitled to the relief it seeks, dismissing its complaint and all causes of action therein, award Ms. Heard her attorney's fees that she incurred and continues to incur in an effort to obtain the benefits due under the policy that New York Marine wrongfully withheld and is withholding in bad faith, award Ms. Heard the costs of the lawsuit, and grant such other relief as the court may deem equitable, just, and proper. Now, you would think that would be the end. Oh, no, 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 no. Oh, no, 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 no. Did you forget who you were dealing with? Did you forget who this woman was? Did you forget what she likes to do? What does Ms. Heard like to do the most when you sue her? Countersue! Yay! Countersuit! Of course, she's going to issue her own counterclaim and say, not only do I disagree with everything you just said, I'm also going to sue your ass right back at you. You ready? Oh, I told you better buckle up. I told you you're in for a long haul. Look at this. Counterclaim by Amber Heard. Pursuant to Federal Rule of Civil Procedure, the counterclaim by Amber Heard here defendant New York Marine and General Insurance Company and alleges as follows. The nature of Ms. Heard's action. New York Marine sold Ms. Heard an insurance policy in which it promised to defend and indemnify Ms. Heard against, among other things, lawsuits alleging that she defamed others. When Ms. Heard was sued by Johnny Depp for defamation, she timely notified New York Marine and asked New York Marine to defend her. Typo. While New York Marine promised to do so, it did not provide the full and capable defense to which Ms. Heard was entitled. It failed to pay attorney's fees and costs that it was obligated to pay for Ms. Heard's defense, and it acted in other ways that prejudiced Ms. Heard and her defense. So right out of the gate, exactly what you would expect, right? Her lawyers are arguing like, wait a minute, not only are you not entitled to declaratory relief and nullification of the indemnification clause, but you absolutely violated the contract and you need to pay now. In acting in this manner and as described in greater detail below, New York Marine breached its contractual duties, tortiously violated the insurance policy's implied covenant of good faith and fair dealing. There's a lot of repetition here if you are noticing, but this is now her own counterclaim. Like she is countersuing, right? She loves to do. She did it to Depp. She's doing it to New York Marine. Maybe she'll do it somewhere else. I don't know. We'll see. New York Marine's conduct and its coverage, implied covenant of fair dealing, and repudiated the duties that it still owes to Ms. Heard while she pursues her appeal in the lawsuit. Again, this is in the past tense because the lawsuit and the appeal have been settled, brought by Mr. Depp. New York Marine's conduct and its coverage positions are contrary to the terms of its insurance policy, the law, the facts, and insurance industry custom and practice. There we go. Ms. Heard is entitled to recover damages to compensate her for the injuries that New York Marine has inflicted and punitive damages because of the New York Marine's tortious bad faith. Once again, jurisdiction and venue, standard stuff. We're just going to skip over that. Parties. Ms. Heard is an actor. Okay, we got that out of the way. She has appeared in such films as Aquaman and Justice League. Ms. Heard is informed and believes on that basis alleges that New York Marine is a corporation organized and incorporated under the laws of the state of New York, and its principal place of business is in New York. Ms. Heard is informed and believes, and on that basis alleges, that New York Marine is a sophisticated national insurance company that holds itself out as offering excellent customer service and an experienced claim handling team. Now, pay attention to the language, because the language here is going to be the dead giveaway of the tone that her counterclaim is trying to set for purposes of her counter lawsuit. And language for lawyers is everything. We live on language. We used to charge by the letter. That's why we had these long, drawn out. It is hereby forthwith with between the two parties alleged of the two, and the claim as follows. Well, all you had to say is Bob and Joe say this, but instead you have like 2 paragraphs. That's because lawyers used to charge by the word because there's no way to keep time back then. Hundreds of years ago. So pay attention to the language. Ms. Heard also is informed and believes, and on that basis alleges, that New York Marine is part of a co-action, which is a co-action specialty insurance group, And that coaction advertises and makes public statements, including on its website, on behalf of New York Marine and its other member companies, including New York Marine. Ms. Heard is informed and believes, and on that basis alleges. See how everything is speculative. Everything is speculation. And they're letting the court know that to make sure that they don't accidentally state something wrongfully. That is the proper way to do that. That coaction uses its website to market its insurance products, represent the nature of its insurance products, its policy underwriting, and its claims handling, and represents the quality of insurance and service customers of its group members will receive if they do business with the coaction company. Ms. Heard is informed and believes, and on that basis alleges, that New York Marine authorized the statements and representation that coaction has made on its website, and that those statements and representations are made on behalf of New York Marine. Ms. Heard is informed and believes, and on that basis alleges, that when coaction say things through its websites, advertising its statements, it is speaking on behalf of and is authorized to speak on behalf of New York Marine. Coaction represents to the public and to its customers some values. What are they? They say that there are intrinsic beliefs and are important in and of themselves. Among other things, coaction states as follows on its website. Today, quote, today, coaction is a full specialty underwriter across 5 major product verticals: property, casualty, entertainment, executive liability, and multi-line. Coaction's authentic, collaborative, and results-oriented culture is reflected in the focus. Can you smell the stick up their asses? Because I swear to God, I can. I can smell it from here. Results-oriented culture is reflected in the focused approach the company takes to fulfilling the need of each individual customer by combining product, analytics, and underwriting capabilities with strong industry knowledge and partnership to develop real-world solutions. Customer-focused, we serve the customer, whether they be the broker, the policyholder, or another internal or external customer. It is fundamental that everything we do at its core of a focus of our decision making, integrity and respect. We consistently display honesty and consider it. What the fuck does this have to do with the lawsuit? Will somebody please tell me? That's normal values. That is fine. These are core values of the company, which I don't have any problem with. But what the heck do they have to do? Get to the point here, Husky. Come on, Jesus. Whew. We consistently display honesty, respect, wishes, right, tradition. Okay, even once no one's watching. Accountability. We accept responsibility for our own actions. Okay, fantastic. We don't care. Coaction also represents to the public and to its customers that its special expertise in providing insurance to companies and individuals in the entertainment industry. Among other things, they state as follows on their websites. We are experts. We're a specialty company. Again, not very relevant. I'm waiting for it to tie in. Writing for entertainment purposes. Okay, fantastic. Tell me more. Only not on this. Anything but this. Coaction has been writing entertainment business for over a decade, over 300 years of collective experience. Okay, our target customers are artists and entertainers. Again, we don't care. Coaction also states in its entertainment fact sheet final, at Coaction we strive to provide an excellent claims handling experience to our clients. Fantastic. Our average claims adjuster has over 15 years experience. They're strategically aligned and are underwriting vertical to provide our insured and claimants a specialized claims encounter. Fantastic. Irrelevant. Objection. Move on. Experts claim, including experts claims team known for its quality and commitment and integrity. Okay. Policies are underwritten by the insurers of Coaction, including New York Marine and General Insurance, and Coaction has $1.1 billion estimated 2022 premium and $3.2 billion total assets. Fantastic. Give me the meat. The policy. New York Marine sold insurance policy number such and such to Amber Heard. Yes, we covered that. The policy contains multiple coverage parts, up to $1 million. Yes, for personal and advertising injury. Each occurrence, $1 million. Yes. Next. Policy's commercial general liability, coverage B, obligated New York Marine to pay those sums if Ms. Heard becomes legally to pay as damages because of personal or advertising injury. Right. So far, so good. So up until this point, they kind of agree in a way, if you notice. The only point of contention is going to be the willful conduct or non-willful conduct. That's what I'm guessing. But I don't know how they're going to get away from it. I can't wait to get to this point. Because so far, they're just beating around the bush. And is also obligated to defend her. So to pay damages and to defend her against any suit seeking damage to her personal or advertising injury. Any injury in a written manner that libels a person. We got it. All right. The policy's comprehensive personal liability coverage to pay up to its limit of liability for damages. Okay. Got it. And that's the definition, which they did not contest. To the extent not waived or otherwise excused, Ms. Heard has complied with all the terms and conditions contained in the policy. Boom. So that's point number one that Amber and her team are trying to make. To the extent not waived or otherwise excused, they're saying Ms. Heard has complied with all your terms and conditions, and therefore she's entitled to the benefits of this policy. Interesting. Objection, please clarify. In March 2019, Ms. Heard's ex-husband filed a lawsuit against her in which he says that she defamed him. And in June, the lawsuit returned a verdict against her for the 3 counts of defamation. She appealed it, and the appeal is currently pending. This was at the time of the filing. As we now know, the appeal is resolved. Now, New York Marine, they're saying breached its breaches in bad faith conduct. Ms. Heard timely notified New York Marine of the DEP lawsuit. No question there. Sounds like she notified them immediately or shortly thereafter after it was filed. But New York Marine initially agreed to defend Ms. Heard subject to a reservation of rights. So they reserved their rights because here's the problem. But New York Marine did not know at the time the suit began is that the jury is going to find her liable for willful conduct, acting with actual malice. And in that scenario, this is what New York Marine is arguing. We are not liable to indemnify you or to defend you in case you get sued. Because now the verdict showed that her conduct was willful. Basically, New York Marine was betting that Amber was going to win. That's what I think happened. New York Marine put its chips and said, oh, it's a sexual assault case. Obviously, she's going to win that. Everybody's been winning those lately. Like Weinstein lost, Bill Cosby lost. Like all those guys were just getting tanked, you know. So they're like, oh, Johnny's just going to go down with the ship. No pun intended, right? Like everybody else. Well, to their surprise and chagrin, they realized, oh, wait a minute. She was found to be liable for the defamatory statements. Are you kidding me? Holy crap. Yeah, mulligan. See, I'm not the only one doing mulligans here, Viking Wolf. They said, well, that changes everything, doesn't it? That changes the game for us. Because before we were obligated to pay, before we knew that your conduct was willful, knowing, and done. Intelligent is a loose term. It's not like did it in a smart way, but did it with conscious understanding that I'm doing it. It wasn't like she woke up one morning and sleepwalked to the computer, typed up the whole, defamatory article, hit publish, and, went back to sleep, woke up. Oh my God, what happened? What have I done? That would not be knowing and intelligent, right? And it would be unknowing and unconscious. But because her conduct was willful, this is what New York Marine is arguing, and her lawyers are counter-arguing that you said you're going to pay, you agreed, you don't get a chance to mulligan now. And New York Marine is going, no, we agreed before we knew that her conduct was intentional. The policy has a specific exclusion that says if your conduct is willful, we don't have to pay. If your conduct is negligent, then we pay. And the jury verdict has clearly shown that your conduct was willful. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. That's what the crux of this argument is about. Now, pay attention. Um, New York Marines breaches in bad faith conduct. This is what Amber's team is arguing. Ms. Heard timely notified them, and they initially agreed to defend Ms. Heard subject to their reservation of rights. Now, unfortunately for Ms. Heard, New York Marine Performance never lived up to its promises. This is what they're arguing. Indeed, New York Marine never fully paid Ms. Heard for her defense, leaving Ms. Heard to incur hundreds of thousands of dollars in defense costs not paid by any insurer, withdrew from Ms. Heard's defense, expressly repudiated its duties to defend or indemnify. Repudiated is a fancy word for backed out, and has consistently placed its interests above that of Ms. Heard's. Specifically, in October 2019, New York Marine reserved rights to deny coverage on the ground that Ms. Heard behaved intentionally, thus creating a conflict of interest with Ms. Heard and giving Ms. Heard the right to independent counsel, with New York Marine being obligated to pay for the fees and costs of this independent counsel. Nonetheless, New York Marine refused to agree to defend Ms. Heard through independent counsel and instead, appointed its own counsel. Despite requests from Ms. Heard to reconsider, New York Marine persisted in its position, making it impossible for Ms. Heard to fully accept this defense provided by New York Marine without prejudicing her defense in the DEP lawsuit. New York Marine's appointed counsel ultimately withdrew on November 20th, 2020. Wow. Just absolutely wow. Ms. Heard is informed and believes, and on that basis alleges that New York Marine thereafter agreed to participate in the defense of Ms. Heard by reimbursing Ms. Heard's defending insured Travelers for some of the amounts it had paid and was paying towards Ms. Heard's defense in the DEP lawsuit, but has never done so. So they also, this is going to be the one we're going to talk about Thursday, is Travelers' involvement in Travelers' lawsuit with New York Marine. That's a whole subject in its entirety, but it's briefly mentioned right here in paragraph 21 of her countersuit against her own insurance company, and was paying towards Ms. Heard's defense. Thus, at no point has New York Marine fully honored its duty to defend Ms. Heard in the DEP lawsuit. Once judgment was entered in the DEP lawsuit in accord with the jury's verdict, New York Marine took the position that it need not defend or indemnify Ms. Heard, even though that judgment is not final, has been appealed, even though it's over now, and may be reversed on appeal, which now will never happen. Ms. Heard is informed and believes, and on that basis alleges, that New York Marine took this position to benefit its own economic interests at the expense of Ms. Heard's interest, and even though it knew or should have known that on this basis, for this position, they're contrary to law and do not excuse New York Marine's duty to defend Ms. Heard. So what they're saying is, regardless of all of these facts, they had an affirmative duty and should have defended her in her conduct, and their failure to do so is breach of contract and is breach of their fiduciary duty. They're acting in bad faith, and so on and so on, right? By refusing to provide the defense which Ms. Heard was entitled to in the DEP lawsuit following, and as well as the appeal, and by wrongfully asserting that Ms. Heard is not entitled to indemnity for any amount that Ms. Heard might be legally obligated to pay in any judgment or settlement in the lawsuit, which we now know its settlement is for $1 million, New York Marine has wrongfully repudiated and refused to perform its duties to Ms. Heard. In so acting, New York Marine has deprived Ms. Heard from receiving the full benefits that she was promised and to which she is entitled under the policy. Oh my God. Do you realize how much is riding on this lawsuit right now? Now that the case is settled, because before there still was like, maybe she can win and blah, blah, blah. There was all this talk. Now there is no more talk. This is it. This is it. Everything is riding. $1 million is on the line now for Ms. Heard. She's always in trouble, isn't she? Always has something that she has to rely on in order to redeem whatever little victory that she has or potentially may have. It's been an L after an L after an L for her, and she is probably praying that this lawsuit is resolved in her favor. Otherwise, she's going to have to pay $1 million out of her own pocket, plus everything that she owes to her own lawyers, right? I mean, this is just absolutely insanity. How much she has riding on this. I would not want my worst enemy to be found in this position. I'll be honest with you. I mean, this is crazy. This is absolutely crazy. So, of course, in the countersuit, you have to allege some causes of action. Without causes of action, there is no lawsuit. All these facts up until this point have been fine and dandy and cute, but without a cause of action, you have no lawsuit. So here are the causes of action. First, breach of contract. We saw that coming a mile away. You failed, you had a duty under the policy, the law, and insurance industry custom and practice to fully defend Ms. Heard in the DEP lawsuit, and their duty arose at least at the time it received notice of the suit and continues until the suit is resolved, including all the appeals therein. They had a duty under the policy to investigate, to support her coverage, and had a duty to give at least as much consideration to Ms. Heard's interest as it does to its own interest. So they're saying everything that the insurance company is doing is all self-interested. They're putting themselves ahead of Ms. Heard. New York Marine breached its duty when they refused to fully and properly defend her in the lawsuit, to indemnify her in the amounts that Ms. Heard may be legally obligated to pay in the DEP lawsuit settlement, which we now know is a settlement, refusing to perform its duties under the policy and acting as alleged above. As a direct result, Ms. Heard suffered damages exceeding, and why it says exceeding $75,000 is because that is the minimum required amount in controversy to be in federal court. Second, tortious breach of the implied covenant of good faith and fair dealing. It's going to be a lot of the same language. So we're just going to hit the high points. They agreed, they had a covenant to act in good faith and fair dealing, and they would do nothing to interfere with Ms. Heard and the rights received under the policy. They failed to do that, denied her coverage, and that was improper. And as a result of that, they gave their greater consideration to their own interests instead of Ms. Heard's interests, failed to handle the claim guidelines, etc., and in fact committed acts to which Amber Heard has a right to recovery. Their acts are inconsistent and run contrary to insurance industry and custom. And as a direct result, Ms. Heard sustained and continues to sustain damages to be proven at trial. Ms. Heard is informed and believes that on that basis alleges that New York Marine, acting through one or more of its officers, directors, or other corporate employees with substantial independent and discretionary authority over a significant aspect of New York Marine's business, performed, authorized, and or ratified the bad faith conduct alleged above. New York Marine's conduct. Now, this is where the language gets really fucking colorful. Listen to this. New York Marine's conduct is despicable and has been done with a conscious disregard of Ms. Heard's rights, constituting oppression, fraud, and or malice. New York Marine has engaged in a series of acts designed to deny Ms. Heard the benefits due under the policy. Specifically, New York Marine, by acting as alleged above in light of the information, facts, and relevant law to the contrary, consciously disregarded. Does that sound familiar? Ms. Heard willfully committed the acts. Now New York Marine is consciously disregarding. I wonder where they got this language from. Right? It's crazy. It's crazy. I wonder if Amber had any hand in like drafting this last paragraph. It's like, do you guys mind if I like do a little? Do I get a turn? Oh my God. In light of the information, facts, and relevant law to the contrary, consciously disregarded Ms. Heard's rights and forced Ms. Heard to incur substantial financial losses, thereby inflicting substantial financial damage on Ms. Heard. New York Marine ignored Ms. Heard's interests and concerns with the requisite intent to injure with the meaning of California Civil Code Section 3294. And therefore, Miss Heard is entitled to recover punitive damages. Oh, they want punitives now. Because of bad faith, you're entitled to punitives. If they can prove bad faith, they can recover punitives. Sneaky, sneaky. Is entitled to recover punitive damages from the New York Marine in an amount sufficient to punish and make an example out of these motherfuckers. I'm sorry. I got a little too into character. To make an example of New York Marine and to deter similar conduct in the future. Prayer for relief. On the first count, damages to proof at the time of trial plus interest. And on the second count, proof for the damages to be proven at trial, as well as punitive damages to be determined at the time of trial. Signed, her lawyers, attorneys for Amber Heard. Wow. Just wow, you guys. I disappeared for a moment. I'm sorry about that. Just wow. So, what does this mean? What does all of this mean in English, right? This means her insurance company that owes her $1 million, they're saying, we don't owe you $1 million because you acted willfully. And even though we agreed under a reservation of rights to represent you, now that the facts have come to light that your conduct was willful, not negligent, and you acted with actual malice as the jury has voted and signed, and the order was entered on June 24th, we don't have to pay you shit. You basically voided the insurance policy. Imagine a similar scenario would be you driving down the road and you see your ex's vehicle and you're like, oh, that motherfucker, like, and you slam on the gas to wreck into them intentionally. Here's the question. Is the insurance company liable in paying you for the damages that you caused to the car? Answer, no, they are not, because your conduct went from being negligent to being willful. And you also have a clause in your car insurance contract with your car insurance company that protects the insurance company from having to indemnify you in case your conduct is determined to be willful by an adjuster or by a court or a jury or a judge. Same thing here. This is what her insurance company is saying. We thought, and this is where they placed their bet and put their chips in, they said, look, your conduct was negligent at best, or excuse me, at worst, or at best, there was no conduct at all. It just, you're gonna win this, and Johnny's gonna lose. They followed the cookie cutter pattern of the Me Too movement, basically. They're like, the women always win. And that has been the pattern because most of the actions brought forth have been truthful and honest and by real victims of domestic abuse. They never imagined that this is an anomaly, that this is a made-up story about facts that never happened. They weren't ready for that. And you know what? Who can blame them? They were following the trend just like anybody else. They were like, they weren't even thinking. But then when the jury verdict came down on June 1st and it was entered by the court on June 24th of last year, that's when the game changed. And they were like, wait a minute. Oh, shit. This was willful? If this is willful, we don't have to pay, and we're not paying. That's exactly what it boiled down to. Now, her lawyer is also saying that they should have paid throughout, and they didn't. That may be a separate argument. Maybe they should have been paying up until like June 24th. Maybe. A court could, in theory, say that because they had a duty and they didn't learn about the willful conduct until June 24th. That could actually be a W for Amber. I don't know how much money that would be, but Or maybe the court will say, nope, the fact that it's willful, it backdates to the date of your reporting, or even further, it backdates to the date of the publication, and they don't owe you jack shit. So they could go in many different ways. It depends on the law of California and how it looks at it, because we haven't seen any briefs. These are just the complaints and the complaint and the answer. Like, this lawsuit is literally just beginning. The answer to the counter complaint, the answer to the counterclaim by Amber. So the original complaint was filed in July, what we read today, and the answer and counterclaim were filed at the end of November, like right as the briefs were being filed. I remember right before Thanksgiving. And the reason it's been taking so long is because she had so many other things that were happening. They just kept asking the court to delay proceedings, and that's normal. That's standard stuff. Now that everything is in order, everything has been filed, everything is good, now the question becomes, where do we go from here? Here's what I think will happen. And this is my prediction. On the 13th, her insurance company is going to have to file an answer to the counterclaim. With that, we'll begin the discovery process. So now that the settlement has occurred, because don't forget, between the counterclaim, the filing of the counterclaim, and the answer to the counterclaim by her insurance company, we have the settlement that sits right in the middle. So that resolves already affirmative defenses 2 and 9, as we discussed. So that means there are only 7 other affirmative defenses remaining. And now it's up to the court at some point will be to decide after they receive, well, let me back up. So here's what's going to happen. They're going to begin the discovery process. They're going to start looking at case law. Does the insurance company have to pay when, after it agrees with the reservation of rights, after it says, I will defend you and I will indemnify you up to $1 million per occurrence, which in this case it's one occurrence, so $1 million. Do they have to backdate it if it is later determined to be that the willful conduct, that the conduct has actually been willful? That's the question that both sides will have to answer. And if the answer is, it doesn't matter if the conduct was willful or not, if at the time that the policy was instituted, they agreed to defend and they agreed to indemnify, they must do so, then they will. They will have to pay. Maybe up to June 24th when the judgment was finally entered, and that changes the stakes. Maybe up until December 19th when the settlement occurred. Or if the case law says that nope, it basically unravels the entirety of the contract, the entirety of the agreement, the entirety of the covenant, that I promise to defend you and I promise to indemnify you in case of a lawsuit. If it is later determined that the conduct is willful, and this is where I'm leaning to agree with her insurance company, because that makes more sense. And usually, even without looking at the law, usually the answer that makes more sense is the correct one, in my experience. I could be completely wrong. But based on what we know and what I know, it seems to me that the answer that makes the most sense is, especially because they did a reservation of rights, because they were like, look, we agreed to defend you unless it later turns out that we didn't have to. And the policy clearly states that if it is later determined that your conduct was not negligent but was willful, then we don't have to pay you. The court will look at it and go, well, it was later determined on June 24th, and the court entered an order that your conduct was willful, not negligent. That unravels, undoes their agreement to indemnify and defend you. And therefore, they don't owe you this money, and you're on your own. That's my prediction. Again, based on common sense. Because what's the alternative? The alternative is the insurance company goes, I promise to defend you. And later it turns out, because it's about fairness, right? How is that fair for an insurance company that has a clause in its policy that says we do not defend intentional torts and this is an intentional tort, and it's later determined to be an intentional tort, well, you have to pay anyway because you said you would. That just it doesn't pass the smell test. You see what I'm saying? It doesn't pass the smell test. What does pass the smell test is the court going, you know what? Yeah, you don't have to pay. You learned it after the fact, no question, but it's a fact that is unchangeable, unmalleable, factual. So it's crazy. It's absolutely nuts. I don't know what Chad is talking about. Chat is all over the place. Let me catch up on some super chats. Thank you all for participating and being here. By the way, I love every single one of you. Don't forget to like this video, comment below, subscribe to the channel, join on as a member if you haven't already. And if you have a question, please type it up. If it's a super chat, I'm more likely to see it. But some of you who know me, I don't only read super chats, of course. Viking Wolf by Blood says, I know you all are going to think I'm weird, but I cannot wait for this insurance shiza. I am 52 and have been in the insurance industry for 30 years. Yes, 30 fucking years. Sorry, I added a word there, but I think it's merited. Very cool, Viking. I didn't know that. So I think she said that in the very, very beginning when we started doing this. I'm a little bit behind because I was focused. I wanted to make sure we got the all complaint, the both of the complaints, the complaint and the answer and the counterclaim read first. Mark Evans says, I'm playing this live stream from the beginning at 2x speed. Its audio is amazing. Scuff is perfect. So should I keep the first 5-6 minutes of this thing? What do you guys think? I don't know. I'm afraid that people will start watching it and be like, I can't understand this guy. Like, I'm not watching an hour and a half of this motherfucker going, hi everybody, hi, it's good to meet you. So I'm thinking of deleting it, but let me know in the comments and in the chat if you want me to keep that, squirrel voice. Oh man. Balam's ass. Doo-doo, gonna put it on you. I hope I read it in the way it was intended. Viking Wolf by Blood says, makes more sense to just cut the check to Johnny, or rather the charity he chooses to give it to, because he does not want the money. Everyone is saying keep it. Are you guys serious? Okay. I'm afraid it may get few views. I don't know. Viking says that put the chipmunk at the end with comments on how it started out. You know what I mean? Call it a mulligan. I could. That's harder. See, you're making me work. I don't like to do that. Oh my god, keep. All right, I'll just keep it. Fine, whatever. Screw you guys. Screw you guys. I'm going home. In the voice of Cartman. I don't know, Viking. Makes more sense to just cut the check to Johnny. The problem is she would have to pay out of pocket, and she wants her insurance to pay, so it's not going to be. Don't be so hasty. You know what I'm saying? Don't be so hasty. Fasten your seatbelt on easy chair as we ride with Mr. Larry Foreman Alexander. By the way, just shout out to Alexander real quick. This Canadian motherfucker who I love to pieces, who has been with the channel for like, what, a year and a half? I lost track of this guy. He has been an absolutely wonderful, wonderful staple to the channel. And he, the other day, was like, I want to ship you a package, and can you do a live where you open it, like unboxing, a live unboxing of my package? So I'm going to do that when I get home, because the package is waiting. It finally arrived today, like earlier today. And I'm going to do a live unboxing on my channel for you, my guy. So it's going to be fun. It's going to be great. It's going to be awesome. Thank you for that, by the way. Honestly, that's totally unnecessary, unanticipated. I don't know if it's a Christmas gift, a New Year's gift, but I will take it, my friend. Welcome, Cerebear, Siribeary, to the channel. Also welcome Ginger Snap to the channel. Solon The Lich says, Amber Heard, New York Marine is in league with Adam Waldman and that umbrella guy. Of course. Come on. Who's not a non-conspiracy theorist around here? Everyone is a conspiracy theorist. Amber Heard will say that everyone is in bed with everyone against me. Jen Gremspring says, catching a bit of your live stream. Thank you for the recent court readings and explaining. You got some explaining to do, DUI guy. You're funny and it's natural. Thanks. Kids need me. I'm going to go. Comforted in knowing you and maybe 4 others get the truth. Wow. That's a extreme minority. I keep moving the rug where the camera is. No! Don't get disconnected on me. Okay. Whew. What a night, huh? Thank you, Jen Gremspring. Another staple to the channel, by the way. Gamer Soldier 100 asks, if Amber defaults on $1 million settlement, so default means she doesn't pay, does it go back to the original settlement? Would she get to try to appeal again? Now, that is a great question. That is a great question. I imagine in the contract that they signed, in the settlement agreement that they signed, there is a clause for what happens in the event of non-payment. So we can play the guessing game. But more than likely, we're not going to get it right because we don't know what's written there. It could be anything. However, in the event that it's not written, and it's going to be up to the courts to decide, like in courts, I put in quotation, like in metaphorical courts. And Johnny has to go to collect the $1 million so he can give it all to charity. No, it will not go back to the original settlement because the $1 million now dominates. That is the settlement. It resolves the whole appeal, because you have to remember, in a contract situation, because what is a settlement agreement? It is a contract. A settlement contract requires 3 things: offer, acceptance, and consideration. This is literally day 1, class 1 of law school, hour 1, minute 1 of law school, contracts class. Offer, acceptance, consideration. Offer, Amber, I will drop the appeal if you drop $9.35 million and drop your appeal. Acceptance, Johnny, I agree. I will drop my I just dropped my 9.35 million, and I will drop my appeal. Just drop yours. And the consideration is exactly that. The 9.35 million, she still owes 1, and they're both dropping their appeals. Because you can't have like a contract with, I will pay you $1 million if you do nothing. I mean, doing nothing in theory could be consideration if the alternative was to be doing something. Like, I will give you $1 million not to jump off this bridge, even though you're not doing something, but it's a very specific not doing something. You don't jump off the bridge and I owe you $1 million. You know what I'm saying? So it gets hairy. But it can't be like a contract to commit a crime. Like, I will give you $20 if you break into that house over there. You get the idea. So no, it will not go back to the original settlement. They will come after her for the $1 million that she owes. Elusive Red says, I propose a live reaction video of today's intro. Okay, I will take that into consideration. What do people say? Yay or nay? What do you guys think? Vote in the chat or in the comments below. Do you want me to do a live reaction of today's intro of the Chipmunk Larry? Whew. Island Taz says, so with Amber Heard being found, it's not guilty. I know people like to say, guilty of malice. She wasn't found guilty. She was found liable. I know guilty is a lot easier to say, like she's guilty of defamation, but it's not a crime. Defamation is a civil suit. But I understand. Everybody says it. I think even I said it a couple times on accident, just because it's just so silly. But it makes sense, right? People are like, they feel like she's guilty because of the notoriousness of her lies. That's what's driving people insane. Like they want Amber to be guilty of something because it doesn't make sense for her not to be. So with Amber Heard being found guilty of malice, does that mean she took out an insurance policy under false pretenses? That is another question that I was actually wondering when I was reading. So remember, she took the policy out in July, and then she was probably already planning on writing the op-ed sometime around that time. So she preemptively took out that policy. 5 months later, she writes, because these are not policies that people normally take. Like, when was the last time you have seen somebody take out this sort of policy? But she is an actress, so maybe, I don't know. There's an argument to be made both ways. Did she have a policy beforehand like that? Has she maintained a policy throughout? There's so many questions. There are so many questions, and I cannot answer them because I'm not privy to this information. So, taking out a policy, taking out a policy under false pretenses, would be a crime in and of itself. Meaning, you are prepared that you will probably be sued, and you just want to be covered just in case. But at the same time, may not necessarily be, because if you anticipate that you may be in litigation at some point in the future based on acts that you intend to commit, and this is why this is why people take out policies in the first place, to be covered in situations like that. Like you can't take out a fire insurance policy. I'm sure some of you may have heard of this gentleman. I forget where it was. He took out like 5 fire insurance policies, like in case he loses the home by fire. He took out 5 policies, and like a week later, his home magically burned. Oh my God! Surprise, surprise! Right now, that was clearly under false pretenses because they determined the fire was an intentional act. He took the 5 fire policies because he knew the house was going to burn down because he was the one that was going to do it. And that's an easy one. But taking a policy under false pretenses is a crime in and of itself. The only problem is you have to prove it, and that is going to be a hell of a fight. So I'm not surprised why her insurance her insurance company is not arguing that, because that would be extreme. That would be literally like, you are a fraud. You defrauded us. But as you can see, they are not alleging that, at least at this juncture. That may change. Maybe after they see this video, they're like, oh my God, DUI Guy's audience is giving us ideas. Maybe we should file a lawsuit against Amber Heard for fraud. We haven't thought of that. Who knows? I don't know. You'll be amazed. I mean, you know how much the public's eye of law tubers and YouTubers in general have changed the course of this trial, to where Camille Vasquez and Ben Chu instituted several things that we law tubers discussed on our respective channels, and they actually like took some of those tidbits and used them in their own trial. I mean, it's unbelievable. It's unbelievable. And not just LawTube, all of YouTube collectively, the internet collectively, anyone who was in the public sphere, and they were able to get their hands on that information. So, will Amber have to pay interest? I think you left that out, retired Nana. Probably not. Probably not, because interest is usually on judgments, court judgments. On settlements, there's usually no interest unless it's embedded in the contract again as well. We don't know. We don't know. And what happens now? Well, we're waiting on the answer to the counterclaim, to the answer by New York Marine to Amber's counterclaim. That's going to happen on January 13th. Excuse me. So 10 days from today. That's next Friday. And after that, they will probably begin the discovery process, which is basically sharing of documents amongst themselves. If it gets to that point, for example, New York Marine may file a motion to dismiss or motion for summary judgment based on failure to state a claim upon which relief may be granted against Amber and her claims, which is likely and very possible. And if that's granted, then it will just be New York Marine pursuing their claims. Um, but and then depositions, exactly, Lana, exactly. That will come much later, maybe like by summer, I would say, late spring, early summer, if we're lucky. And then yeah, and then might be a trial next year. Highly unlikely. I think that we'll settle this way before it gets to trial. Um, but yeah, I am going to go and enjoy a comedy show at Yamashiro's. So thank you all for joining me. It's been so much fun. It's not over. The saga continues, and we have more documents to go over. I'd be curious to know, says Carrie Davidson, when she was approached to write the op ed. Me too. You and me both, Carrie. So thank you all very much for joining me. I very much appreciate every single one of you. Thank you all for being here. Thank you all for paying attention, because I know I threw a lot of stuff at you, but I hope I made it as simplified. I tried to simplify it as much as I could, and I hope I made it make sense. Thank you all once again. Join me tomorrow, 10 a.m. Pacific, 1 p.m. Eastern. Claire fucking Best is coming back to this channel to tie Amber Heard and FTX together. What? The biggest crypto conspiracy and Amber are related? Do tell me more. Bye, everybody.